Hello everybody, so welcome back to the English Law Channel. I'm carrying on looking at different ways that you can terminate leases, so bring them to a close. So a lease will be terminated by any transaction which means the leasehold estate and its reversion is owned by the same person. Okay, this is merge and surrender, the leasehold and the estate, like that. So Lord Millett in Barrett and Morgan 2000 said this: a surrender is simply an insurance by which a lesser estate is yielded up to the greater, and the term is usually applied by giving up the lease or tenancy before its expiration. So that was it. The House of Lords, and that was the Supreme Court. Didn't exist as such. We're talking about the law lords and the House of Lords. The judges seems to have said yes to Lord Miller's dissent on property issues, but mainly looked at what is now no longer pertinent, the tax issue. So surrender means you have to have a deed at law, but a contract for surrender is also something which operates in equity. So informal surrender is implicit with the landlord and tenant behave in a way which is completely inconsistent with the lease carrying on. Now there are suggestions for reform. The Law Commission has often said that there has often made propositions for reform in this area. And so in 2006 there was a report called Determination of Tendencies for Tenant Default, and this is what it said. It has long been recognised that this area of law is in need of reform. It has been the subject of frequent criticism for many years. It is complex, it lacks coherence, and it can lead to injustice. That's the end of the quotation. So the Law Commission is a government body of barristers, solicitors, is not MPs, and they look into law. They're meant to be bipartisan, and they make suggestions. What are the anomalies? What are the problems? How can it be tidied up? And then it's up to Parliament to implement these proposals or not. So therefore, the Law Commission suggested in 2004 a consultation paper that the present law ought to be amended. So the abolishment of some current provisions, and it's a replacement by a statutory scheme whereby all termination proceedings would be heard in court, and that would be fairer to the tenant. But the scheme was seen to really be really fulfilling that proposal. The Law Commission's report on renting homes, which came out in 2003. The 2006 report was more exact, and in its suggestions that the Landlord and Tenant Termination of Tendencies Bill ought to go forward. But the objectives of the proposed scheme for forfeiture would be making it more straightforward and streamlined and letting everybody know what's going on. It would be just changing the equilibrium of rights. The situations that would make forfeiture permissible were called tenant default, and that would permit forfeiture whether the landlord had the right of re-entry or forfeiture in the clause or not. So waiver of a breach would be got rid of. A tenant default notice, which is similar to our Section 146 notice, would have to be served by the landlord if the breach were not put right. Then a court could decide whatever to impose whatever remedy it saw fit, and it will have to bear in mind proportionality, which is a key principle of justice. And there were 6 suggested orders. Anyway, the government's done nothing about the 2006 report. Okay, so let's look at tenancies which run with the land in reversion. So a lessor, the one who's leasing it out to another, can assign their reversion, and the lessee can assign the lease. A deed is needed for the legal assignment of reversion of the lease, and it doesn't matter how short that term of the lease is. Lots of leases have a covenant which prevent assignment, subletting, or parting of possession of the land without the landlord's say-so. And in cases as per section 19.1 of the Landlord and Tenant Act 1927, this says the consent cannot be withheld without good reason. If the tenant wants consent and it's unheld unreasonably, then they can go ahead and assign anyway, even without consent. The Landlord and Tenant Act 1988 says the landlord has to fulfil particular obligations pertaining to giving and withholding consent. Well, let's look at how enforceable these covenants are. So the Landlord and Tenant Covenants Act 1995 took effect on New Year's Day 1996. Now, this caused some major changes to law in this sphere, but lots of its provisions were only applicable to leases that began after 1995, and therefore the previous law is still valid with regard to leases that began prior to that. So therefore, you have to know both systems. So anyway, so looking at the old leases and the new leases. So the new leases as per the Landlord and Tenants Covenants Act 1995. So the original lessor can give out the assignee of the reversion, or the original tenant and the assignee of a lease. So how about leases prior to 1996? Look at the original parties. Remember the doctrine of privity of contract? The original parties are still liable on the covenants of the lease for the duration of the term of that lease. So Lord Templeman talked about this in City of London Corporation against Felber in 1994. He said the common law did not release the original tenant for liability for breaches of covenant committed after assignment. The fortunate English landlord has two remedies after assignment, namely his remedy against an assignee and his remedy against the original tenant. So I'll go over that. Arabella is the landlord, so she leases the property to Belinda. So Belinda is the lessor, and then she assigns it to a sublessee, Charlotte. So Charlotte's living in the house, Belinda's moved somewhere else, but Belinda is still the tenant. So Charlotte pays rent to Belinda, Belinda pays some of that rent to Arabella, and no doubt keeps a chunk of it herself. But then if Belinda is doing something wrong, then the landlord can sue Belinda. If Charlotte's doing something wrong in the house, breaching the covenant, then the landlord can sue Charlotte, but doesn't have to. Could just sue Belinda if she finds that easier, more convenient, thinks that Belinda's going to sort it out, going to pay. So you can sue either of them. So this is very tricky, particularly for that original tenant, Belinda in this case. An instance of this was Centro Vincial Estates against Bulk Storage 1983. The original tenant was liable for 2 quarterly instalments, as in a quarter being a period of 3 months, so 6-month instalments of increased rent which wasn't paid by the assignee of their lease. The rent was initially £17,000 per annum, and that was put up to £40,000 per annum. So this was regarded to be deeply unfair to the original tenants who hadn't done anything wrong. But that's the risk you take by subleasing, so don't do it. City of London Corporation fell, Friends Provident Life Office against British Railways Board 1996. They sought to restrict how this is going to operate. In Fell, the House of Lords said, okay, we'll make a concession to the original tenants by saying they're not liable for rent left unpaid by the assignee of the lease if the term of the lease has extended beyond the original 10-year lease by the subsequent assignee. In Friends Provident, the Court of Appeal said that the original lessee was not bound by later changes of the lease between the landlord and the assignee, unless the change had been foreseen in the terms of the original lease, for instance having a rent review clause. Moreover, the pre-1996 leases, the Landlord and Tenant Covenants Act 1995 now limits the right of a landlord to recover rent from the original tenant after assignment through Section 17. The landlord has to serve the original tenant with a warning that they might be liable for the assignee's breach. This is called a problem notice, and they have to do it within 6 months of rent becoming due. So this reduces the tenant's possible liability to 6 months worth of rent in effect. Still a lot, but that provision is inapplicable to damages owed for the breaches for non-rent covenants, breaking other covenants which are not rent. But Section 19.1 gives a right to the original tenant to be made liable to the assignee's breach to recover the leasehold interest in the land. So when they pay the full amount, that means they can get some major compensation. So looking into the assignee of the lease, bear in mind situations in which people other than the original parties to the lease can sue. They can sue on covenants in that lease. So in the case of an assignment of the lease, the rule is that both the benefits and the burdens pass on if two conditions are satisfied. The first one is the covenants must touch and concern the land, so actually be about the land. And second, I'll have reference the subject matter of the lease. So most books have lots of lease of covenants that have been held to touch and concern of the land, and the ones which are held not to touch and concern the land. For instance, Hua Chao Commercial Bank Limited against Chua Hupa Industries Limited 1987. And they're the Privy Council, the Judicial Committee of the Privy Council, which is the Supreme Court for lots of Commonwealth jurisdictions, in that case Hong Kong, found the landlord's obligation to return the tenant's deposit when the lease ran out did not touch and concern the land. But in Kumar against Dunning 1989, the Court of Appeal found that the covenant, by a surety guaranteeing the payment of the rent, did touch and concern the land. Swift Investments against Combined English Stores 1989. Here the judges in the House of Lords said that Kumar against Dunning was correct, and they said the test is going to be applied like this. Is the covenant benefited only the reversioner for a limited period? Did it impact the nature, quality and mode and use or value of the reversioner's property? And was it not expressed to be personal? There's another general requirement that the privity estate must be between the lessor and the assignee of the lease. So therefore there must be a legal lease, for instance, purchase against Litchfield Brewery 1915. Purchase being a surname, not just meaning buying. So there has to be a legal lease of assignment of the whole term. Now, if these conditions aren't fulfilled, the common law rule in Spencer's case, 1582, is applicable, and it states that the benefits and burdens of covenants that touch and concern the land will pass to the assignee of the lease. Okay, so let's look at assignees of the reversion. Through sections 141 and 42 of the Law Property Act 1925, the benefits and burdens of the covenants have reference to the subject matter of the lease will pass on assignment of the reversion, even if the lease is not by deed. See Rickett and Green, 1910. The assignee is the only person entitled to sue, even in breaches about the covenant, even though it occurred before the assignment. Look at Ray King, 1963, London and County A&D Limited against Wilford Sportsman, 1971. So look into sublessees. These are who is renting it from someone who is himself a lessor. So if there's no privity of contract or privity of estate between the lessor and the sublessee, so covenants in the lease are not directly enforceable against the sublessee under that rule in Spencer's case, 1582. But restrictive covenants can be enforceable in that case, Tulk and Moxie, 1848, that celebrated case about the land which is now Leicester Square. Further, the head lease might have a forfeiture clause, and the lessor can re-enter and determine the lease for breach of covenant, even, probably, if the breach of covenant is not touching and concerning the land. So the sublease is brought to an end, unless the sublessee can find some remedy. So the ideas here are applicable where the equitable lease has been assigned or where there's been an equitable assignment of the lease. So let's look at the situations after 1995 and the Landlord and Tenant Covenant Act 1995. So no difference was drawn here between equitable and legal leases or equitable and legal assignments, as per section 28. The benefit and burden of covenants passes on the assignment of the lease or reversion unless they're expressed to be personal. It doesn't matter whether the covenant touches and concerns the land or not. In the first Penthouse against the Channel Hotels and Properties 2004, the meaning is expressed to be personal. So let's look at the original parties. In relation to post-1995 leases, the Landlord and Tenant Contracts Covenants Act releases a tenant from covenants after they've been assigned, as per section 5, unless the assignment is breaking a covenant or by operation of law, section 11. So the Act says that the procedure for the release of the landlord from their covenants after it's been assigned, section 8, is contingent upon their giving notice of the assignment to the tenant and the tenant not refusing. The Act takes some steps towards abolishing privity of contract in this area. So the usual scheme is that the tenant assigns their lease and then they are freed from the covenants, although there is the possibility the landlord can extract an authorised guarantee agreement. In cases where a landlord's consent is required to an assignment, the landlord can try to make the tenant sign an authorised guarantee agreement, and the tenant acts as a guarantor for the person to whom the tenant assigns it, as per section 16. So let's look into assignees of the lease and assignees of the reversion. There are not many covenants which do not touch and concern the land, as per the Act. The requirement that they touch and concern the land is done away with. So all landlord covenants and tenant covenants automatically pass on assignment of either reversion or the lease. So section 3 of the LTCA covers the transmission of these covenants, but personal covenants are ruled out, are exempted. Okay, that's as per section 3.6. BHP Petroleum against Chesterfield Properties 2001 found that all the terms agreed by the original landlord and tenant pass automatically unless the covenant is qualified to make it personal, with a liability between the people who originally signed the covenant. So here the covenant was just a personal one, and therefore it didn't come under the Landlord and Tenant Covenant Act. So a liability for purely personal covenants is not something which can pass on to the assignee. So the original landlord is therefore liable for the whole period of the lease about personal obligations on them to fix anything that's broken in the premises. So the Section 8 procedure for releasing a landlord from the obligations is not applied to a personal covenant. Further, an assignee has no rights or liability about pre-assignment breaches. So let's look into sublessees. The rules about this, about the enforceability of contracts against sublessees, they're not impacted by the LTCA 1995. London Diocesan Fund against Avon Ridge Property Company Limited 2005. The lease had an express term which freed the landlord from landlord covenants, immediately assigned his interest in the properties to another party. The tenant said that this term was nullity because of the Landlord and Tenant Act 1995. because it was trying to circumvent the requirements of Section 628 of the Act. The House of Lords, they said this argument was meritless, and they said that the term had to be upheld. Okay, so the average clause allows the original tenant to get out of liability under the lease without having to serve notice on the tenant. So it nullifies a key element of the Act and shows the House of Lords still regards lease as contractual creations. That's enough from me. Toodaloo.